Welcome to today's webinar, Legislative Response, Confronting Domestic Violence, brought to you by NCSL. All lines have been placed in a listen-only mode to provide favorable sound quality during today's presentation. It is now my pleasure to turn the floor over to Annie Teagan. Ma'am, the floor is yours.
Hello. Good afternoon to most of you, and good morning to those on the Pacific time zone. Welcome to the webinar, Legislative Response, Confronting Domestic Violence. My name is Ann Teagan, and I will be moderating the webinar today. I'm a program principal with the Criminal Justice Program at the National Conference of State Legislators, and I have recently taken over covering firearm policy here at NCSL. Our webinar today is being recorded, and registrants will be able to access a recording of the webinar and presentation slides on NCSL's website. We will send out a notice shortly with a link to these resources, and you will also be able to download a PDF version of this as well. We will also have a question and answer period after our three presentations. Please enter your questions in the Q&A box, and I will ask our speakers to address them following the presentations. Your questions will be visible to all participants. Before we begin, I would like to thank all the presenters and guests for participating today. Domestic violence continues to be a problem in the United States, and state legislators are dedicated to finding ways to curb this behavior. States are looking at domestic violence in a lens that touches on topic areas like confidentiality, protection orders, public assistance, and child support. Our presenters today are Megan McCann, Colin Weaver, and Representative Brian King. Megan McCann is a Senior Policy Specialist with NCSL's Children and Families Program. She conducts research and technical assistance in the areas of child welfare, child support, family law, and human trafficking. Prior to joining NCSL, Megan graduated from the University of Wyoming College of Law, where she participated in the Domestic Violence Clinic as a student attorney. Our second speaker is Colin Weaver. Colin has spent his entire career in state legislative advocacy, elections, and politics. As Director of State Affairs at EveryTown for Gun Safety, Colin directs the organization's 50-state legislative strategy and program that has passed landmark, proactive legislation in red, blue, and purple states alike. Before EveryTown, Colin spent several years creating and running comprehensive issue advocacy campaigns in New York State for nonprofits and government agencies. Our third and final speaker today is Representative Brian King, the House Minority Leader in the great state of Utah. He is a member of the House Judiciary and Revenue and Taxation Standing Committees. He currently serves as the Chair of the Judicial Conduct Commission for the state of Utah, and he also serves on the Board of Directors for the Rape Recovery Center and on the board for the ACLU of Utah, and is also a member of the American State Legislators for Gun Violence Prevention. And now, on to the program. Megan, the stage is yours.
Thank you, Ann, and thank you everyone for joining us today. I'm thrilled to be here to provide the legislative overview of domestic violence policy across the country. I'll sort of start out with a brief overview of NCSL and what we do here and how we provide a service to state legislators. NCSL is a bipartisan organization that serves legislators and legislative staff in all 50 states and territories who are all members of our organization. NCSL has three primary missions listed here. First, our office in DC provides a strong, cohesive voice at the federal level on behalf of states. Second, our Legislative Staff Services Program works with legislators to improve the institution itself. And third, our State Services and Policy Division provides research to states to support state legislatures. As part of that division, I'm with the Children and Families Program. There we cover issues that would generally fall under the Human Services umbrella, including early care and education, child welfare, welfare and poverty, child support and family law, and domestic violence. Part of the work around domestic violence is answering information requests on behalf of state legislators and staff, as well as legislative bill tracking. My presentation will be a brief overview of the issues we see addressed most by legislatures. First, and probably the issue that we see the most and get the most questions around, is protection orders, including the three main buckets listed here. First, what is a protection order? We do answer a lot of questions around civil versus criminal protection orders, as well as the duration of protection orders, how long they last, what is temporary, what is permanent. It's a big topic of conversation among states. With this comes questions about expungement of those protection orders as well. The second question is, what does a protection order protect? Each state has a statutory provision detailing what protections are included in a protection order. Some states are more extensive than others, but they all cover a wide range of things. Nearly 10 states restrict the defendant from changing the utilities on the formerly joint residence. So it's sort of the broad change, prevents the defendant from changing the utilities, shutting the utilities off, and that includes the cell phone. In addition, 10 states prohibit threats made to a partner and treats those threats as a separate offense. And then the third question is, who is actually protected by a protection order? Who is able to get a protection order and against whom? The vast majority of states and territories allow protection orders for adult victims of dating violence. And just about half of states allow protection orders for teen dating violence. When it comes to same-sex couples, most state statutes are silent, but there is a lot of language, and the language around the relationship necessary to get a protection order is fairly broad in most states, including cohabitating partners, household members, dating relationships, and intimate relationships. Some also state that the statute should be liberally construed, which would allow coverage for same-sex couples. Related to protection orders is the issue of address confidentiality, or protecting the victim's address and information about their whereabouts or job within the protection order process and following the issuance of a protection order. At least 41 states have address confidentiality programs. Many of these programs address the needs of victims of domestic violence, sexual assault, or stalking broadly. They protect the address of a victim in court documents and other correspondence that may provide information to a defendant. This can also include, as I mentioned in the previous slide, cell phone contracts that both parties may be included in. Some also specify address confidentiality programs within their voter registration program. One unique and often overlooked issue is the intersection between domestic violence, public assistance, and child support. Federal law requires temporary assistance for needy families, and under certain circumstances, Medicaid applicants to cooperate with child support enforcement. Some states have elected to include child support cooperation requirements into their child care assistance and SNAP programs. While financial stability is critical to custodial parents who have experienced domestic violence, and child support has the ability to help, in some states, child support enforcement will automatically open a case and serve the non-custodial parent without the applicant knowing or participating in the process. This could put the custodial parent at greater risk. The number of people affected by these policies has the potential to be significant. Research from the late 1990s shows that nearly half of women receiving cash assistance have experienced domestic violence at some point in their lives. Additionally, just over half of families in the child support caseload are currently receiving or have previously received cash assistance. Good cause exemptions and domestic violence waivers are an option that would allow a domestic violence victim to access public assistance programs without having to cooperate with child support enforcement. While the majority of states have a good cause exemption or domestic violence waiver included in their cooperation requirement, they vary in how they inform parents of the option and what evidence or documents is necessary to receive that option. Also, the use of these mechanisms is quite low. In fact, data from 2015 shows that 33 states reported 0% of their TANF caseload with a domestic violence waiver from cooperation with work requirements. Only a handful of states reported more than 1% use of a domestic violence waiver. In addition to the issues of public assistance and domestic violence, the ability to identify domestic violence as a risk factor in any child support case is important. A study from the Child and Family Research Partnership at the University of Texas found that 43% of mothers surveyed who did not have a formal child support order and who are not receiving any child support reported experiencing domestic violence by the child's father. 37% of surveyed custodial parents who did have a formal child support order reported experiencing domestic violence at least once by the time their child was 3 years old. Within the child support program, family violence indicators are the mechanism used to flag cases as including domestic violence. This automatically leads to modified case management procedures, including address confidentiality. Child support and court staff training, as well as flexibility in what child support enforcement mechanisms are used in a particular case, are other ways that states have addressed the crossover. In addition to public assistance and child support impacts, domestic violence also touches other issues, including custody determinations and professional training. The majority of states consider domestic violence as a factor when determining custody arrangements, and nearly half of states have created a rebuttable presumption against awarding a perpetrator of domestic violence custody or visitation. Another trend that has popped up this last legislative session is mandating training for cosmetologists, estheticians, barbers, and other professionals in the field around domestic violence, identifying it, and providing resources to clients. Illinois was the first state to enact legislation in 2016, and in 2017, more than a dozen states have introduced similar legislation. Much of that legislation is still pending, and NCSL is tracking that and will be able to report later this year. In terms of policies directed towards domestic violence perpetrators, electronic monitoring, better intervention programs, and other treatment requirements, as well as firearms, are other considerations states have looked at. Electronic or GPS monitoring is allowed in many states for defendants that are eligible for pretrial release. 9 states specify that electronic or GPS monitoring is allowed for defendants charged with domestic violence who are eligible for pretrial release. 23 states have pretrial release provisions requiring mental health treatment, domestic violence specific counseling or classes, or requirements for participating in courses of treatment that are medically recommended. There's not a lot of information around better intervention programs, both where they exist and their effectiveness. But a recent report from New Mexico's Legislative Finance Committee looked at their better intervention programs and the effectiveness. The report shows siloed programs, lack of accountability to complete better intervention programs, and other issues, and it recommends various strategies for improving the effectiveness of those programs. Access to firearms has also been an issue that states have considered, but I will let Colin get into the specifics of that in a moment. NCSL has lots of resources from our children and families, health, and criminal justice programs, covering everything from impacts on families and basic domestic violence information, injury prevention, and pretrial release issues. A few of them are listed here. I kind of went through everything pretty fast and a wide variety of issues, but if you have any questions after this or you'd like further information about any of the issues discussed, don't hesitate to contact me and I'd be happy to share my resources. With that, I'll kick it back over to Ann and we'll move on.
Thank you so much, Megan, for that update on state laws in this arena. Please remember that you can ask a question anytime in the chat box. And now, Colin, the floor is yours.
Great, thank you so much, and thank you to NCSL for putting on this really important webinar. NCSL's role as for state legislators and for staff and others is really unparalleled, and I think it's a really fantastic opportunity to be able to talk about this really important subject today. So let me just start talking a little bit about sort of who EveryTown is and sort of who we are. EveryTown was originally formed as a coalition of hundreds of bipartisan mayors from around the country. Let's skip too far there. Of bipartisan mayors from around the country who were banded together in order to try to utilize their positions as elected officials to try and find a new approach, a new vision for reducing gun violence. Mayors Against Illegal Guns became EveryTown for Gun Safety, a full-service research and advocacy organization that has staked out a middle ground position away from the extremes on both sides of the gun issue that is doggedly data-driven, bipartisan, and full of some of the foremost policy and legislative affairs experts on firearms in the country. One of our founding principles has been to do everything we can to help keep guns out of dangerous hands. And certainly a big part of that is keeping guns away from domestic abusers. There we go. And, you know, as we, so EveryTown's team, policy and legal experts set out to better understand the link between domestic violence and firearms. After analyzing the existing research from academics, poring through various data sets, and conducting our own original research and investigations, some of which you can see here, the connection between domestic violence and firearms was abundantly clear. And it became clear also that this was an issue that needed to be addressed, particularly at the state level. And what that research found was that domestic violence and guns are so clearly connected. What you see here are just a few of the stats that begin to tell the story of how domestic violence and violence against women is so strongly associated with firearms. In America, a majority of fatal domestic violence is committed with firearms. The second stat shown here is particularly startling because it so clearly demonstrates that when domestic abusers have access to guns, domestic violence can quickly turn into domestic homicide. So we know that domestic violence and access to firearms are very much intertwined. The question then becomes, so what it is that we're going to do about it? And as we look to approach solutions at the state level, I think it's first probably important to understand just briefly a little bit about sort of existing federal laws and its limitations as they relate to guns and domestic violence. Federal law does prohibit certain abusers convicted of domestic violence crimes, including misdemeanor crimes of domestic violence, and those under active final restraining orders from possessing guns. While these federal laws are certainly beneficial, the truth is these particular federal laws are difficult to enforce at the state level, and they don't go nearly far enough in protecting all victims of domestic violence. And the evidence is clear that we need strong domestic violence laws at the state level in order to keep guns out of the hands of domestic abusers. Among other policy recommendations, it is important for states to have laws that at the very least match existing federal law in order to allow state and local law enforcement to enforce the law when they encounter an abuser in illegal possession of a firearm. And these are, have mirroring federal law to have prohibitions on people convicted of misdemeanor crimes of domestic violence and those subject to final active restraining orders. The truth is federal officials are never going to have the resources to prosecute every abuser found to be in illegal possession of a firearm, but that doesn't make the abuser any less dangerous. This is where having state laws that at least match existing federal law is so important. It's also critical that prohibited abusers be required to turn in guns they already have. If an abuser is subject to a final restraining order is allowed to go home and have access to their existing guns, that creates a very dangerous situation for the victim. Laws that require abusers to turn in their guns they already have will help save lives and protect victims. We also need legislation and policies passed that require state and local law enforcement be notified when abusers and other prohibited purchasers try to buy a gun and fail a background check. A really compelling statistic that is maybe not entirely related to domestic violence comes out of Colorado that showed, where data there showed that on average, one convicted murderer or one person currently under arrest for a murder charge tried to buy a gun at a Colorado gun store and failed a background check. So an average of one per month. Those are incredibly dangerous people, and at the very least, we should be notifying law enforcement when that occurs. And that context is particularly true in the case of domestic violence, where we know that time is incredibly important in terms of safety and protecting victims. And to account for all the different ways that domestic violence can manifest itself, we need to go beyond federal law and actually expand the definitions of who should be prohibited purchasers, including prohibiting convicted stalkers from possessing firearms. And we also need to close what we call the boyfriend loophole, which is ensuring that domestic violence crimes apply to dating partners in order to keep guns away from abusers. And you'll see here on this next slide that just providing sort of an overview of some of the stats on the number of states that have some of these policy recommendations that I just sort of briefly went through. You can see that in 27 states and in Washington, D.C., they require the domestic restraining orders, people under those orders be prohibited from buying or possessing guns. Within that, 16 of those states actually require relinquishment of existing firearms, and 17 states include a dating partner definition as well. And for misdemeanor crimes of domestic violence, 27 states require a prohibition for people convicted of domestic violence misdemeanors from buying or possessing guns. And within that, 13 of those states actually require a relinquishment of the firearms they currently possess. And 16 states with required MCDV prohibitors include dating partners. And as you can see from that, the numbers vary a little bit, but roughly half of the states that actually have these prohibitors in place, only roughly half of those even require that these people actually turn in firearms they currently own. And that's, as we'll get to a little bit later, is an incredibly important piece of this work. Again, looking at convicted stalkers, 18 states and Washington, D.C. Prohibit all convicted stalkers from having guns. And to the point about the sort of notifying law enforcement when somebody fails a background check, 6 states currently require law enforcement be notified after a domestic abuser or other prohibited purchaser tries to buy a gun and fails a background check. There are additional 3 states that practice but do not require in law that law enforcement be notified when a prohibited purchaser fails a background check. And so I think it's important also to fully understand the need for some of these strong gun laws. So we've talked a little bit about sort of the policies that are policy options that are out there, the states that have them and don't. But I think when going through the needs of these laws, I think some of the work that we've done in Rhode Island is a really good example. After reviewing every single final domestic violence protection order in Rhode Island between 2012 and 2014, our research showed that despite clear evidence that firearms were present and used to threaten victims, only very rarely were judges ordering these abusers to turn in guns they already owned. And as you can see here, some of the evidence that was being provided where victims were saying that their abuser will threatening to blow their head off and putting a gun to their head. And despite all of the very clear and convincing evidence of the dangers of having firearms in those particular abusive situations, judges very, very, very rarely were ordering those firearms to be turned in. There is some, just a quick sort of current affairs update on that. While certainly we are not there yet, the good news is that the state of Rhode Island actually just passed out of its House committee a couple of days ago legislation that actually would close this loophole and actually mandate that judges order surrender for these firearms in these instances. I think another good example to look at in terms of sort of the need for these strong domestic violence laws comes out of the state of Washington. If you take a look at the 2 yellow arrows on the screen, you'll see that data from the FBI showed that over 15% of people who failed a criminal background check at a gun store in Washington state were denied because of a link to domestic violence. So you see where people who are under a domestic violence protection order at 7% and those who have been previously convicted of a misdemeanor crime of domestic violence at over 8%. And these numbers don't even include domestic abuse situations in which somebody is prohibited from possessing a firearm where there's a felony conviction in place. These are just purely for just these 2 separate categories. And we're talking about over a couple of decades, these are thousands of abusers who went and tried to purchase firearms. When a prohibited domestic abuser tries to buy guns, law enforcement should be notified. And I think another piece to understand, as we've looked at certainly the need for these for strong domestic violence laws. There's also, it's very clear that when these laws go into place, the impact is very clear. As you can see here on this slide, the impact in Colorado when they passed a law to require those subject to a protective order to relinquish firearms in their possession. You can see in 2011, 2012, it was basically non-existent. And then as the law was implemented in July of 2013, you can see that the numbers have steadily grown in the percentage of cases in which the firearms have been ordered to be surrendered. Now, certainly, there is room for improvement always in enforcement, and certainly we work in states that absolutely do, but absolutely making progress, and that is, hundreds, if not thousands, of abusers who no longer had access to their firearms during the course of their protection order. And I think, in talking about the need for the laws, the impact the laws can have, in the past couple of years, states are acting to keep guns out of the hands of domestic abusers. Since 2013, 23 states have enacted 33 separate laws to help keep guns out of the hands of domestic abusers. This really is tremendous progress on this issue, and it is one that, frankly, legislators should be absolutely proud of. And there's certainly more work to do, but the momentum is there, particularly over the last couple of years, where states are absolutely taking action. And I think, as you'll see from that map on the previous slide, these laws are passing in red, blue, and purple states alike. Crafting and passing legislation is certainly never easy, but this issue has seen incredible bipartisan support over the last several years. Bills are passing out of chambers with overwhelming bipartisan support, and of the 23 states that have acted since 2013, laws were signed by 10 Republican governors and 13 Democratic governors, respectively. Elected officials know that domestic violence gun laws will help, most importantly, will help protect victims. And it's also clear that there is strong support among voters. As you'll see in this, that there is overwhelming support for policies that keep guns out of the hands of domestic abusers. This is a sample of statewide polling that EveryTown conducted in 7 very diverse group and set of states that shows that voters of all parties in all regions of the country support passing state laws that, in this particular, for this particular question, state laws that prohibit anyone convicted of a misdemeanor crime of domestic violence or subject to a domestic violence protection order from purchasing a gun. And so it's very, very clear that these laws have a good impact, and that this is exactly the type of legislation that voters and the public at large actually want our elected officials to be working on. And the end result of all this is that the dangerous link between domestic violence and access to firearms is clear. That state-level gun laws are absolutely necessary and have significant impact, and they're badly needed to protect victims. And that states in the last couple of years have been stepping up with bipartisan support to pass laws to keep guns away from domestic abusers. And so that concludes my portion for today.
Thank you so much, Colin. We will now hear from our final presenter, Representative Brian King. Representative King, the floor is yours.
Thank you so much. I appreciate that, Megan. I am a legislator here in Utah. It's a red state, as you all know, and I got this bill passed last session that I thought was an important piece, and it ties into a lot of what Colin was saying. I had a lot of help from EveryTown, but I also had help from a number of other gun violence prevention organizations. The American State Legislators for Gun Violence Prevention was actually the place that first gave me this idea a couple of years ago to run this bill. And basically it was, as Colin referenced, saying to the state legislature, why don't we put in place at the state level in Utah a replicating of the federal prohibitions on the ownership, purchase, or possession of guns by individuals who have been convicted of domestic violence, whether felonies or misdemeanors. They're obviously prohibited from ownership or possession or purchase of guns if they're convicted felons, but if they have been convicted of a misdemeanor involving domestic violence, that falls under the Lautenberg Amendment, which has been in place at the federal level for many years. But not nearly as many states as ought to have those same laws in place do, as you saw from the slides that Colin presented. Probably less than half the states across the country replicate those prohibitions on the state level. So I didn't know out of the chute when I started talking to people about this how difficult or easy that bill would be to pass. Utah loves the guns. We have lots of guns in the state. I'm a gun owner myself. And we have many members of the chamber in the House who themselves are not only gun owners but are concealed weapon permit holders and who bring and have guns with them every day on the floor of the House. I knew that, and I didn't know what kind of resistance I was going to get to this bill. But it was important from my perspective because, as you can guess and you know, there are federal resources available to enforce these prohibitions on the ownership and possession and purchase of guns. But if you can replicate those prohibitions on the state level, you're going to find that the resources available to enforce those laws at the state, county, city, municipal level are much greater. And they're going to put a lot more teeth into that whole thing. So I went ahead and talked to my folks in the Second Amendment community and said, listen, what do you think about this? And was gratified and a little surprised in some situations to find pretty strong support for this idea that so long as we kept the bill to the parameters that exist under the prohibitions in federal law and didn't try and expand it, didn't try and deviate from that in any meaningful degree, that they were for the most part okay, not all of them, but the people who were the loudest voices in the Second Amendment community here in Utah, which included current state legislators, former state legislators, lobbyists, the Shooting Sports Council in Utah, their lobbyist is a big hitter in terms of his voice. And even the National Rifle Association on a federal level supported the idea. They didn't come right out and support the bill. What they did is they said, we're willing to work with you so long as you deal with this in an open-handed manner and show us your drafts of the bill and let us know what you're doing and let us review it before it's made public and you take it to a committee and present it so that we can know whether we need to be concerned or not. We'll work with you on that. And they did. They were very helpful. And so it kind of ties back into something that we all know as legislators, which is so much of what we can accomplish, whether it's in Congress or whether it's in state legislatures or whether it's in county commissions, county councils, doesn't matter what level of policy making or lawmaking you're at, so much of this is relationship-based. And I found it very important and helpful to be completely open-handed and upfront and have the buy-in and the involvement of folks on the front end of this process, Second Amendment folks, as well as people within the domestic violence community. EveryTown was very helpful, as I mentioned before, but our state coalition against sexual assault was very helpful. Our state domestic violence coalition was very helpful, and they all provided a great deal of input. So that was an important thing from my perspective in trying to get something positive passed through the Utah State Legislature. I think that many of the ideas that EveryTown and others are talking about are things that I want to move forward with. The foundation that was provided by the passage of this bill that was passed in the last session to replicate in state law the prohibitions that exist in federal law, that's the legal foundation on which I think we can move ahead now and build in ways that, again, Colin referenced in his slides about taking action to actually get guns out of the hands of these folks. And it comes in the form of better reporting when individuals try to purchase and can't do it because they do have a domestic violence conviction in their background or a permanent protective order, or it has to do with better communication between federal and state agencies, better communication between the individuals that end up with that initial screening when the person tries to purchase a gun and they fail the background check because they're a convicted domestic violence abuser, you need to have some method that is effective of having that information communicated to law enforcement, communicated to AP&P, adult probation and parole, communicated to the judiciary, and once that information is effectively disseminated, then coming up with a method that's effective to work with the law enforcement agencies, make sure that we, without endangering our police officers and without endangering family members, have those weapons turned in. And other states, of course, have done this. You saw Colin's slide on Colorado. I was happy to see that. But once you have a more effective method of putting in place notification of individuals who shouldn't own guns or have failed a background check, effectively notifying the courts and the adult probation and parole, the people who were prosecutors who were dealing with pushing those cases through, you're going to increase the likelihood that you get the guns out of the hands of people who shouldn't have it. So those are all things that I think are worth pursuing, and we're going to be working on that, continuing to work on that in Utah in the future. One of the other things I wanted to just briefly talk about was a really tragic situation that we had crop up here in Utah not long ago, a couple of weeks ago actually, where you had a woman who got in some sort of involvement, a relationship involvement with a personal trainer that she was working with, and he became fixated on her, the degree to which they had a relationship that sort of was the basis for his stalking and fixation. I'm not certain of the details of that, nor does it matter. But he began to follow her around and began to call her and began to, sort of pursue her in a way that was alarming to her. She calls her local police, the city police where she lives, just a couple of days before the incident that ended her life. And she says in this 911 call, look, I'm very concerned about this guy. He keeps calling. He keeps showing up. He is bothering me. We had a relationship at one point, but it was something that I terminated, and he just won't stop following me around. And the folks in the city police department tried their best to sort of assess the lethality, the threat that this guy was to her. And under Utah law, there's nothing that they really felt they could do because there was not a marriage in place. There was not a familial relationship in place. He wasn't a sibling. He wasn't a child. He wasn't a spouse. He wasn't a parent. And, they had at most a dating relationship if they had even that. And so the police said to her, well, I don't really know there's that much we can do. And there wasn't an effective response. And a couple of days later, he shows up at the school where she's walking her child home from school and begins to threaten her, and she walks home, and somebody comes along and picks them up in their car. He follows this woman who is in the car of the Good Samaritan and pulls out a gun and kills her child and injures a couple of other folks. I mean, it's just this enormously tragic situation. And it's actually prompted a lot more discussion in Utah about how we can tighten up these laws, as Colin was talking about, to include dating situations or non-family members. But the point is this. One of the other things I think we can do a better job of in terms of legislative initiatives is to develop and put in place greater lethality assessment protocols, what we call them LAPs. But other states can call them, other communities call them whatever they want. But basically, standard use of validated universal danger and lethality scoring and assessment tools is what I'm talking about, so that law enforcement agencies have available to them, and individuals within the domestic violence community and the mental health community have available to them information that allows them to effectively and accurately assess how lethal a threat is for an individual who calls in on a 911 or visits a mental health professional or visits a domestic violence professional, so that an accurate assessment can be made about the degree to which these individuals who are concerned are in fact in danger, and then also connecting those individuals to resources that allow for them to get the help that they need, get the protection that they need. I think that there's a lot of potential and a lot of worthy work that could be done at the state level to identify what those effective lethality assessment protocols are, make sure that there's a coordinated effort to get service agencies, as I say, mental health professionals, law enforcement professionals, and others all on the same page in terms of recognizing how to use those things, using them effectively, and then lining people up who are at risk with the resources that they need to make sure that they're not injured or killed because of someone's tendency or movement in the direction of becoming more of a threat in terms of injury or lethality. So those are the kind of things that I think we can do a better job of on a state level, and that's really, I have other stuff I could talk about, but I think I'd rather turn the time back over for questions.
Okay, great. Thank you, Representative King. Our first question is going to go to Colin and probably Representative King to some extent on what can states that have stronger gun prohibitions do to help sway or give evidence and to help states that have not yet taken those steps?
Sure. This is Colin. I'm happy to sort of provide a sort of a first crack at that. It's a really good question, actually, and I think that there's a lot of things people can do. One of them is actually one of the most basic, which is particularly when it comes to state legislators communicating with other state legislators or staff to staff or even just the public to other states is, as Representative King was alluding to, he was sort of flagged of this issue maybe a couple of years ago as something potentially to work on in Utah. And I think that there are a lot of legislators, I mean, obviously state legislators know more than anybody else. There's just so much that happens, so many policies and laws and legislation being crafted and drafted that can be quite overwhelming. And I think what happens is I think a lot of legislators actually don't even necessarily know that their own the weaknesses in their own states' laws when it comes to sort of that connection between domestic violence and firearm access. And so I would say, communicating with legislators in other states, staff in other states, can really go a long way towards at the very least, an education of what some of these deficiencies are. And I also think that, and when doing so, I also think it's important to sort of tell the story that I included in some of my slides, and as Representative King can demonstrate by, passing a strong domestic violence gun law in a state like Utah, is that this is something that does have strong bipartisan support, and telling that story is critically important because there are, I can hardly think of, and as many issues that have received this much support, sometimes passing unanimously, as some of these, these DV gun laws. And so I would say communicating with elected officials in other states and providing the information about how these laws have passed in bipartisan fashion and strong support from voters will go a really long way.
Yeah, I think one of the other things that, along with, I agree with everything Colin said, but one of the other things I think that is a way that we can persuade states to take steps that need to be taken is to go to the Second Amendment community folks and say, listen, you want to be a credible voice at the table on this stuff. You don't want to be seen as reflexively negative in terms of any legislation that could impact the access individuals have to guns. Don't you? Because I think that the great majority of the time, those folks are going to say, well, sure we do. They're not going to be wanting to be seen as purely obstructionist. And we have a tendency, especially in this day when we've become so polarized in how we talk about things politically and how we view people that we don't agree with politically about stuff that we feel strongly about, we have a tendency to demonize each other. I know that's true in this area of politics and policymaking, that there's way too often a tendency on the part of Second Amendment, people who feel strongly about the Second Amendment, to feel like you're coming to take away my guns. I mean, I've had people walking around on campaigning that I tell them that I'm a Democrat, and they literally slam the door in my face and say, you're going to take away my guns. I mean, it's just paranoid at times. But the same, I don't mean to say that it's only the Second Amendment community that feels that way. They don't. There are a lot of folks who are so anti-gun that they have, the polarization on this is really difficult to overcome. And I think one of the ways of accomplishing things in red states is to say to individuals within the Second Amendment community, listen, you want to be a credible voice. You don't want to be seen as just obstructionist. Aren't there some things that we can identify as common ground? Aren't there some things that we can identify that you would agree with me? Folks that you would agree with me shouldn't have guns. Sometimes they may say, I don't agree with that. But I think the great majority of the time they're going to say, I do agree, because they want to be seen as credible. And they can't. I think that largely the Second Amendment community has given up the fight that, everybody should have access to guns regardless of what their background is, and domestic violence, of course, is one of those key areas where we have on a federal level for many years now said certain people who have been engaged in certain conduct in their past shouldn't have guns, domestic violence being Exhibit A. So that's part of it, I think, is to appeal to people in the Second Amendment community to say, let's find common ground. And if you won't do that with me, you're going to have your own credibility to speak about this issue at all decreased with the great majority of people, even on the right side of the spectrum, who have weighed in on this issue. So that's one of the things that I think is an effective way of reaching folks.
And as a follow-up question to that, I was just wondering if Colin or Representative King can answer this. Does the federal law have a look-back period for these convictions, or is it a lifetime prohibition? And then also, I guess, a follow-up question would be, do the state laws that mirror those follow that?
So this is Colin. I can take a first crack at it. Under federal law, which was passed back in the 90s, again with bipartisan support, those who are convicted of misdemeanor crimes of domestic violence, it's a lifetime prohibition, and those, and when it comes to the sort of protection orders piece, it's only for that prohibition is only for the life of the protection order. Whether it's issued for 3 months or 6 months or a year, that prohibition expires once the protection order is no longer active.
Yeah, that's my understanding too.
That's very good to know. We do have a second question here. When doing the research in Rhode Island, Colin, did you know how many reports there were with the use of other dangerous weapons such as knives, or was that information not exactly taken into account when you were looking at those reports?
I don't have the exact numbers off the top of my head. A quick sort of note about the methodology. So it wasn't that we just requested specific information. We reviewed in full every single one of the protection orders that was available, and going through it. And so we were able to determine, and get a sort of a full picture of exactly what was playing out. And like I said, I don't have the exact numbers, but there were very few in terms of knives or other deadly weapons, and guns far outnumbered these other weapons. And certainly, all domestic violence situations are dangerous. But I think going back to an earlier statistic that I talked about in the slides in the webinar was, the presence of a gun makes it 5 times more likely that domestic abuse will turn lethal. I think that's a really important piece. And certainly why not only are guns far outnumbering them and other potential deadly weapons in these protection orders, but also because of the lethality and frankly the data and the science behind that shows how much more deadly these things become, and really trying to minimize and eliminate, if at all possible, the chances that these turn from domestic violence into domestic homicide.
Well, and tying too on Colin's point, I think it's clear when you're talking about, ties into suicide too, that guns are so much more lethal than other methods of ending people's lives. I mean, you can kill a person with a knife, there's no question about it. And you can kill a person strangling them with a rope too. But you can't kill them as easily and as quickly And you can't certainly kill them in a way that's as impulsive or subject to impulsivity as you can kill someone with a gun. So there are big benefits, I think, to getting guns out of the hands of people who have shown they either have anger management issues or they have impulse control issues or both those things. That's the lethality assessment protocol, too, that ties into that as well. One of the things that they will ask in our lethality assessment protocols is the person that you're concerned about, is the person that you're complaining about, either stalking or abusing you in some way, are they a gun owner? That's one of the primary areas of inquiry on the lethality assessment protocol. And people who are talking to individuals who are concerned about being at risk for either they're being abused or they are concerned about the possibility of being abused, that's a core question is, are there guns in the presence of the individual who you're concerned about?
Representative King, that just brings up our final question here. I'm really interested in these lethality assessment protocols, and if other states have it. You mentioned that Utah does. And then does that information go to you mentioned that it goes to mental health professionals, or does it go to law enforcement, particularly like in the cases of stalking? I think that's a really interesting kind of program.
Well, certainly it does in Utah. I don't know how systematic it is in Utah. That's an area perhaps that we could do more with in Utah, where it's already, the lethality assessment protocols are already widely used. But to make them more standardized and systematized, to make them more used by every law enforcement agency is something we could do here. I don't have knowledge about the extent to which they're used in other states, but I'll tell you, I think that they are critical to be used by as many people who deal with domestic abuse victims and sexual assault victims as possible, simply because this is the way of assisting the victim or prospective victim hopefully before they get into more trouble, either before the violence begins, number one, or if the violence is ongoing before it escalates and can result in greater injury or even lethality. So I think it's one of these areas across the country that we as legislators hear about often in this particular area as a best practice, as an evidence-based sort of area where you can show that effective use of lethality assessment protocols is going to save some lives.
Thank you, Representative King, and thank you again to Megan and Colin and to all of you out there for joining us today. As a reminder, the recording of today's webinar and the presentation slides will be made available shortly on NCSL's website. Thank you so much for your continued interest and support of NCSL, and I hope to see many people in Boston in August at NCSL's Legislative Summit. And I want you to wish all of you a very good weekend. Thanks.
Thank you.
Thank you. This does conclude today's webinar. We thank you for your participation. You may disconnect your lines at this time and have a great